Welcome to Channel 17, the Town of Colonie Government Channel.
Welcome to Parenting in the 21st Century. I'm Zena Shefchik. Today we're going to have a discussion about the legal issues of child custody and support in New York State with attorney Joanne M. White, who practices in Latham. Welcome.
Thank you.
Would you tell us a little bit about yourself and your law practice?
I've been practicing since about 1992 in the area of matrimonial and family law. I handle a lot of divorces, custody, child support, orders of protection, various matters that would occur in either the family court or in the Supreme Court in a divorce action. Some cases we try to resolve through separation agreements. Sometimes we actually litigate them through the divorce process. I also have some experience having been trained recently as a mediator, although I've not actually practiced as a mediator to date. And I'm involved in the Collaborative Law Association, which is a new organization, which I can talk a bit about later.
Okay, good. To start us off, I assume that one of the most important decisions people have to make who are contemplating separation and divorce is actually the custody and support of their children. Mm-hmm. Would you define for us in legal terms what custody and support mean?
Mm-hmm. Custody really is, with respect to children, and legal custody is what is the decision-making authority? Who has the decision-making authority with respect to the children? Are the parents going to have joint legal custody, which means that with respect to major issues involving the children, their health, their education, their welfare, are the parents going to consult and agree, or is one parent going to have sole custody, meaning that that parent would make the decision solely? Sometimes parents in negotiations will agree to something called modified joint custody, where one parent has the final say. And really, attorneys know that that's really more like sole custody. But there's legal custody. We also speak in terms of custodial access. And courts and lawyers have been trying to get away from the word custody because of the political correctness of that term, or incorrectness of that term, and talk more about parenting time or custodial access. There's physical access, which means where does the child live? And you talk about whether the child is going to be primarily with one parent, whether there might be a situation where the child is equally with both parents, or whether, generally those are the two. And the parenting plans could really vary from anything that the parents devise that works for them or that the court advises.
When they talk about support, are they only talking about? Are they talking about financial support? Is that what support means?
When a matrimonial or family court attorney talks about child support, typically, that is the support of the child. It's devised by statute. The statute provides for a percentage depending on the number of children that you have. Child support statutorily is supposed to be 17% of the combined parental income. What the court does is take the two parties' incomes, add them together, take FICA and Medicare off of that up to the combined income of $80,000. On the over $80,000, typically just Medicare is taken off of the combined parental income, and then they determine the non-custodial parents' pro rata share of the combined parental income. And the child support percentage is set by statute. So for one child, it would be 17% of the combined parental income, and then each parent's pro rata share would be determined. For two children, it would be 25%. For three children, it would be 29%. Four children, 31%, and so on. We also talk about support in terms of spousal maintenance. That does not have a statutory percentage. The statute simply sets forth a number of factors that are enumerated, and courts and parties have a lot more discretion in fashioning spousal maintenance because there really are just the guidelines, things like what were the spouse's contributions during the marriage as a homemaker, or what were the spouse's contributions to the career or career potential of the other party, what are the incomes of the parties, what does the disposition look like that the parties will get as a result of a divorce, what assets will the spouse end up with, the spouse who is seeking maintenance, will she have a very large distributive award? A distributive award is, an award of money that is given to the recipient spouse. If a spouse is getting a large distributive award, the court may look at that in fashioning an award of maintenance.
You're calling it spousal maintenance. Is that the old term alimony?
Yes, and really alimony isn't used in New York State anymore, although, a lot of times clients will come in and say, can I get alimony? And I'll explain it's really considered spousal maintenance.
Okay, that's good to know.
Yeah.
What are the first things, the primary things that parents should consider with regard to their children when they're starting to think or talk about separation or divorce?
I think yesterday I had a conversation with a law guardian up in Saratoga County, and I think he put it very well. He said, I think the parents should think about how they want to present this to the children. How are the children going to be told that mom and dad are thinking of separating? I think it's very important to consider first and foremost the emotional needs of the children. I have a client that I'd represented years ago who's actually become a friend, and I'd spoken with her yesterday about it, and I asked her that question when I was preparing for this interview, and she said, make sure that you point out the emotional needs of the children are the most important thing. They need to know that they're not put in the middle, that it's not their fault, that mom and dad still love them, but that mom and dad just cannot live together anymore. And I think, that's a very common theme, but parents need to be reminded of that all the time, especially in this day and age. There's a trend toward 50-50 custody, which means that the parents sort of split the children in half. I always think of King Solomon, and I say to my clients, you've got to think about what's in your child's best interest, especially if you have a special needs child. What is it going to be like for that child going back and forth? And parents litigate that issue, especially because there's also a case that the Court of Appeals decided that talks about in a split custody case, the deeper pocket pays full support. So you could have a situation where each parent has the child 50% of the time. One parent makes a little bit more money than the other and presumptively is going to be paying 17% of his combined parental income less FICA and Medicare as support to the other parent, even though that parent has the child 50% of the time. And it typically ends up being the father who's in that situation, but sometimes it's also the mother who makes more money. And I guess in this day and age, it really, I've seen it both ways. I hate to see people fighting over money, and I think all of us grapple with that on a daily basis because the trend is more and more that parents are treated equally. The domestic relations law, Section 240 of the domestic relations law says that there is no prima facie right to custody in either parent. So the statute itself is neutral, even though, and I know one of your questions was, how is the mother favored? And I think more and more, my experience with judges, at least in this area, is that they look at the person, they look at the fitness of the parents, and my experience has not been that any judge that I've been dealing with in the last few years is focused on the mother and the mother's being the primary parent, that there being a preference toward that.
You use the term law guardian, and I thought maybe some people in our audience might want to know exactly what that is, if you could just describe that.
Yes, and actually I think the better term these days, I'm actually on a committee that Judge Spain chairs called the Committee on Children in the Law, and they just promulgated revised law guardian standards, and the preference has now become attorney for the child. But the attorney for the child is, especially under the new standards, is supposed to advocate for what the child wants. And sometimes if you have a very young child, that of course could be difficult. Or if you have a situation where there's a parent who feels that the other parent is programming the child, that there's alienation going on, how do you deal with that? But presumptively, the law guardian goes in and advocates for what the child wants, unless the law guardian feels that the child really cannot speak for himself for some reason. And then the law guardian would have to substitute his judgment in a case where there might be severe alienation.
So the law guardian, is the law guardian then an attorney that's the judge orders, or is that what it is?
Typically, in a custody case, you could have a custody case either in the family court or you could have it in Supreme Court in the context of a divorce action. In both situations, the judge will appoint a law guardian, and typically the law guardian is paid by the state of New York, and the attorney for the child, now better name, is someone who is appointed to represent the child, and that person is supposed to meet the child, perhaps meets with the parents. The attorney for the child has some discretion as to how he conducts him or herself. He could meet with the attorneys, only speak with the attorneys, or speak with the parents. But they should definitely meet the child, perhaps go to where the child lives, or at least have a meeting with the child at the office. And they investigate, they advocate for the child. They may request things like a forensic evaluation. Either parent could request that as well, where a psychologist would evaluate the family and speak to collateral sources to give the court more information as to what is happening in a particular family and what is best for this family. But the attorney for the child is appointed by the court and typically paid for by the state of New York.
Now, the attorney for the child is only comes into play when the judge thinks it's necessary. Is that it? Is it in every case?
Anytime that you're in court, either in a custody matter in the family court or in the Supreme Court in a divorce situation, a law guardian should be an attorney for the child should be appointed.
Okay.
And in almost every case that I've ever had, an attorney for the child has been appointed.
Now, as a child in New York state law, is it anyone under the age of 18, or is it?
For custody purposes, it's up to 18. In fact, I was in court earlier this week on a matter where the father had applied for custody of the child, and she was about to be 18, and we fortunately had reached an agreement before her 18th birthday, and it was a very loose agreement as to, basically the child and the father could agree as to the schedule, and the judge said that's very wise given the child's age. But you can't bring a 19-year-old into family court and say, I want custody. You can, however, with respect to child support, the statute for child support goes to age 21. So
it does, okay.
Yeah, so you sometimes have an interesting situation where you have one parent or the other seeking child support for a 19-year-old, and there's no custody order. And parents will come and say, how do I do that? And basically you go into typically family court on a support petition, and you show the judge where is the child living, especially if the parents are arguing it's a 50-50 custodial arrangement. You put in evidence if you're actually having a trial as to who is the primary parent.
Is it possible to develop your own plan for a couple, a parent, two parents, to devise their own plan and come to court, go to court for however they do it, with a plan, and they don't need to go through a lawyer, or do they have to go to court? What are the possibilities?
More and more people are looking for alternatives to litigating cases, and I think that is very good and very positive, and I think the judges and the attorneys are also very cognizant of that. Sometimes the expense that people incur, especially if they're trying a custody case, can just be prohibitive. I was speaking with one judge in Albany County about a case where he had indicated that over $150,000 in legal fees had been incurred by the time the case was tried. And people in our area, for the most part, don't have those kinds of resources. And so all of us have tried to find better ways of doing things, and one way is mediation. Another way recently, which has come to our area, is the Collaborative Divorce Association, where the attorneys are in this association with other professionals who are financial planners, therapists, mental health providers, and they work together as a team, essentially meeting with the parties and working toward a resolution either of a divorce or a custody matter or a support matter. So I think the parents themselves should be involved and should think about what is best for the children. They should, at the outset of the case, sit down with the children, figure out together how they're going to advise the children of what's happening if they're going through a divorce. They should always think about what are the children's needs. If you're having a trial on custody, the judge is really exploring what is going on in that particular family, what is going on with that child. And a lot of times I've had cases where the child has special needs, and we have to bring in people to talk about those needs, or the parents to talk about those needs. The parents are in the best position to know what their child's needs are, and if they have a special needs child in particular, I think they really have to be sensitive to that. A 50-50 arrangement seems that it can work in some cases, even with a special needs child, but You want to be on board with the child's teachers, the child's therapists. How is the child doing in school? How is the child doing in terms of development? Sometimes we'll involve a co-parenting counselor to sit down with the parties. That's been working very well in one case, which I'm litigating with an attorney right now. But we have someone doing co-parenting counseling, sitting down with both parents, getting them to talk to each other. So I think two parents can, if they're comfortable, sit down with each other and devise a plan and then go into court with it. Sometimes I've had people come to me and say, we'd like to put together a stipulation. And I say, yes, we can do that. We could even, if we've reached an agreement before court, we could come in with a proposed stipulation. The judge may still, he'd appoint a law guardian or an attorney for the child. Old habits die hard because I was the law guardian for many years.
I understand.
But they appoint the attorney for the child, and that person would review the agreement, and decide whether, based on their interview of the child and their assessment of the situation, what they're going to advocate for. Are they going to say, yes, this is a great agreement, or are they going to say, I think it needs to be tweaked some? Sometimes the parents go into court, the judge sends them to a mediator, and then the law guardian reviews the mediated agreement, or the law guardian could be involved at the outset in the mediation or before. But I think, certainly the parents should talk to one another when they can. Sometimes you run into situations where there's domestic violence or there's unequal bargaining power because one parent is very intimidating toward the other, and those are tougher cases because, can a mother sit down with a father by whom she's been abused? Sometimes the courts need to deal more sensitively with that. Mediators are not supposed to mediate between a parent and a victim of another parent who's a victim of domestic violence just because of the unequal bargaining power. But I think a lot of times the parents can. I think they need to be sensitive to the children's needs throughout the process. What I run into all of the time is, and again this morning, early morning phone calls, somebody did this, and they think that the children aren't aware, but sometimes it's hard for me to believe that the children don't know what's going on in the household. If one parent has cheated on the other parent, a parent can become very emotional and they want vengeance, they want revenge, and a lot of times, sometimes that can happen, I want custody, I want full custody, or I want sole custody. A lot of times I will say to clients, as one attorney who did a seminar years ago said, I don't necessarily want to litigate sole versus joint custody, that's a label. I think judges prefer to see joint custody, joint legal custody where it can work, not necessarily 50-50 in terms of access, but getting both parents involved in the decision making, getting them to communicate with each other, I think is very important.
I know I mentioned to you before we went on air about father's rights, alienation of affection, and I bring it up because of the high-profile case lately of actor Alec Baldwin, who has just recently written a book about his experience, and he claims alienation of affection with his wife and daughter. And would you just talk about that as a legal concept and what where this father's rights movement came from?
Yes. I mean, I can't truly speak to where the father's rights movement came from except for my own experience, and I think it was that fathers felt underrepresented, undervalued in the court system, felt that maybe mothers were gaining an edge. Again, in my recent experience with the judges locally, I don't see that. I think that they treat people fairly. I think that they look at the whole person. Another attorney might disagree. In fact, one of my colleagues said, I still see a bias toward mothers. But I think judges more and more are taking a problem-solving approach. Certainly, I've noticed that with all of the, Albany, Schenectady, Saratoga, Rensselaer County, typically where I practice. And I think you present the problems, and then the judges try to help you find a solution. Whether you're in court or out of court, out of court you obviously wouldn't have the court system involved. But alienation is a term. It used to be called the parental alienation syndrome, and there was a gentleman called Richard Gardner who wrote a book about that. And courts in New York State don't accept it as a parental alienation syndrome, but they do look at the concept of alienation, meaning that one parent has done something to the other parent which has essentially brainwashed or programmed the children to be very disrespectful toward the other parent. I've seen several situations like that over the year, which have been very hurtful to the parent who is the recipient of that. I think you sometimes have a very angry parent. Perhaps they think that the other parent has moved on. They don't like the other parent for whatever reason. Maybe the personalities are just very different. One or both parties could have mental health issues. There could be a myriad of reasons why this alienation occurs. It needs to be nipped in the bud early, because the longer that it goes on, the more hurtful it is and the harder it is for courts to rectify. And I've had over the years clients attempt to remedy the situation by seeking a change in custody and, various other approaches, monetary sanctions. I think judges need to nip it in the bud early if they can. People try to work with it through organizations like Jewish Family Services, where they'll meet with the parents, they'll do counseling, and again, get that in process early so that both parents are viewed, are looked at, they meet with counselors, their problems are addressed individually, because a lot of times one or both parents could have some issues that need to be addressed in order to figure out why this has happened. The children need to be kept out of the conflict. Again, the parents need to think about the children from day one. They've got these precious little people that are, in their houses, and they may not get along, they may not like each other, they may have been hurt by the other party, but you've got to protect the children. It's extremely important that the children's needs are placed first, and it is not a good thing for a father or a mother to be shut out of the child's life because the parent is angry. The parents need to realize that it's not only hurting the parent, it's hurting the child. A child who doesn't have a father or mother down the road is really going to miss that relationship.
In my research for this discussion, I came across the concept of the best interest of a child as a legal definition. I don't think we talked about that and what factors are involved in that. It's probably a lot of what you already have talked about, but I would ask that you just talk about that.
Certainly the cases talk about the best interests of the child, and a lot of the statutory provisions talk about the best interests. Not only the custody provisions, but also some of the support provisions talk about the best interests of the child. And it used to be, when I was a law guardian, my job was always, I was told to look at the best interests of the child. And now it's more, what does the child want? So the attorney for the child has been steered away so much. It's not that they're not to consider what's in the best interest of the child, but they really have to advocate. They are an attorney, and they advocate for what the child wants, except in those circumstances that I described earlier, where there could be something like severe alienation. But yet, I think what the courts look at and what parties should look at in fashioning agreements is, every aspect of the child, the emotional health of the child. How is the child going to be financially supported? Where is the child going to school? That's one factor. It should not be the only factor. I had a situation recently where people are saying school district, and we're saying, no, that's not the only issue. The court needs to look at what's going on in the household. How does the father treat the mother in the presence of the child? How does the father plan to support the children? Look at all of the circumstances. Do not just focus on one factor, such as the school district. That's only one issue.
So it's a myriad of possibilities that affect the interest of the child.
And obviously sometimes courts need to get information from other sources. The attorneys can introduce evidence, they can introduce cases, but sometimes, as I said, courts might need to appoint a psychologist to do a forensic evaluation. They may appoint there are various things that they can do to get more information. They may want someone to take a look at the home. It used to be with family court, there would be, home studies and things of that sort.
Right. Is there a wide variation in how long a process of determining child custody and support takes? I mean, is it generally less than a year or I guess I suppose there's a lot of factors involved with that too, including how jammed up the courts are, I suppose.
Yes. The judges, I think, have gotten, again, very efficient about getting cases resolved in a more timely manner. When I first started practicing back in 1992, there was a friend of my mother's who said, my divorce went on for 20 years, and don't let that happen to anybody. The judges try to get the divorces over within a year. That doesn't always happen. I had one case where the parties just sort of sat on it for 4 years, and then my opponent just reactivated it recently. But in most cases, there are standards and goals in the family court, and the judges are very cognizant of that, and they really try to adhere to the standards and goals because they have the chief administrative judge looking over their shoulder, and trying to make sure that things are done properly, but also that things are done in a timely manner. So both in family court and in Supreme Court, there are guidelines. And I would say generally the judges will go in a divorce situation for our preliminary conference, and the judge will say, how much time do you need for discovery, which is the exchange of financial information or any information needed with respect to custody and support and financial issues. And we'll typically say 90 to 120 days, and then we'll have a scheduling order. We'll come back in for a final conference. Depending on the county, some judges will set the trial date at the preliminary conference. I find that happens typically, I think, in Schenectady County and Saratoga County. In Albany County, usually the judges will give you a final conference, and then they'll set a trial date.
I know that sometimes relatives try to get involved in custody and support issues. What is looked at? Are grandparents, other relatives, if they're interested in participating in custody or support, is that an issue that has to come before the court as well? Is that something that you recommend be put in a legal agreement?
Well, typically the parents have obviously the primary right to custody of their children, but there are cases where perhaps a parent is unable or both parents are unable to care for the children, and then a grandparent makes an application to the court. And Section 72 of the Domestic Relations Law actually deals with the issue of grandparents, and it provides for visitation, for a grandparent to get visitation in the event of something called exigent circumstances. And it also provides for a grandparent to get custody if there are extraordinary circumstances. And the statute talks about if, for instance, there's been an extended period of disruption, meaning that the child has been, say, with the grandparents for a period of 24 months, and the statute says it could even be less than 24 months. If there's an extended period of disruption, that in and of itself could constitute extraordinary circumstances. Courts look for the person who's seeking custody to at least initially have standing, which means they've had a long-standing relationship with the child. They're not going to get past get to be able to file their petition and pursue their petition and try a case or whatever needs to happen until they can establish first and foremost to the court that they do have standing, that there is a long-standing relationship with the child. In those cases, I've had those cases, and when possible, I think it's important to try to resolve it with the parties if you can. Sometimes, grandparents agonize over that, and then they do go into court after they've tried themselves to resolve it. But they're difficult cases because...
I bet they are.
Yeah, because if they don't win, there's a risk that there'll be no contact, and those are very sad cases.
Yes, and for the children, I'm sure.
Grandparents are very important to children, so the parents need to remember that too. So I think everybody, again, needs to work together. I think as matrimonial and family lawyers, a lot of times we deal with the emotion of things, and we're always sort of having to defend ourselves on that issue. But I think we have to step back and be objective, but we have a different role. We have to be involved with the psychologists and the therapists a lot. So it's a different area of law. It's one that requires a great deal of sensitivity, and yet sometimes you have to sort of put that in check and make sure that you're objectively advocating and seeing the whole picture.
Would you talk a little bit about relocation? When you initially have a child custody and support agreement, and do you write into such an agreement about changing residence, or is that something where you would have to petition the court again? I assume that in certain circumstances you can petition the court for changes in custody and support, and I would assume that would be one. That
would be one of those circumstances, yes. I mean, you'll get either, if you go to family court, say that the parties are not married, you go to family court and you get a custody order, or you go through a divorce and the custody is part of the divorce judgment and the underlying either settlement agreement or stipulation that was placed on the record or separation agreement. So you've got a court order. At the negotiation stage, whether you're in family court or you're doing it through the divorce, if you have a parent who might want to move down the road, perhaps because they have relatives elsewhere, you try to negotiate that when you can, that they would have the right to relocate, or at least, some sort of provision where, the other party would say they'd want notice, 90 days notice. in my experience, it's been pretty hard to get that from my colleagues. My colleagues will say, oh, we don't want a relocation provision. And typically they'll say, well, your client always has the right to go back to court and apply for permission to relocate anyway. But you have an agreement that says that there's parenting time to both parties. So you would have to apply for a modification, because if a father has 50-50 custody or a mother has 50-50 custody and the other parent wants to move, or even if it's every other weekend or once a month, you cannot impair the other parent's right to have access with their child. I've seen judges do it very successfully in Albany County, even when someone wanted to move to Florida sometimes. I once had a judge who said, very, very practically speaking, well, the plane flight is 3 hours, it's not that much different than if they moved to Buffalo. So I think, again, people try to accommodate, but you do have to apply. It's a higher burden. You have to sometimes show, that economically there's a reason why you need to relocate, that there are job opportunities in the other state that you can't have here, that family members are available to care for the child and you have no family members here. So, those kinds of issues come up. And again, you have to establish those. If you're trying the case, you have to be able to introduce that kind of evidence.
We've covered so much, and we're almost out of time. And if you could just offer to our viewers, perhaps you said you could offer some websites that they might go to for some initial basic information before they're ready to go contact an attorney.
Certainly, if you're looking for an attorney, there are websites. There's the Martindale-Hubbell, which is nationwide, international actually, which lists attorneys. A lot of attorneys, especially in smaller practices, don't necessarily put a lot of information in Martindale-Hubbell. There are various websites like divorcesource.com. I can't really advocate for any of them. I haven't myself really gotten on a website, but I know in this day and age, if you hit Google, a lot of people come into my office very well informed because they have gone on the internet, they've pulled up the New York State statutes. There's a lot of information out there. There are a lot of books.
And before, one more thing I just thought of. What would the advice be when people are looking for an attorney? What should they look for?
Well, let's see. And for a divorce attorney or for family law attorney?
Yeah, family law. I mean, is there something special they should?
I think, obviously I think that they should, experience is certainly helpful. Look at how long has the attorney been practicing. Look for, obviously a good fit with the attorney. I think a lot of times we joke that the attorney, the client will say, that attorney's just like my husband, or that attorney's just like my wife. I mean, I think people tend to look for attorneys with whom they share things in common sometimes. Some attorneys, some male attorneys will say they're looking for a woman, or women will say, I think it's a personal thing to some extent. I think people need to be comfortable with their attorney. They need to be able to talk to their attorney. They need to feel like their attorney is compassionate and cares about their case. People who've come to me, have said that those kinds of things are important to them. Sometimes they're feeling very intimidated by going and meeting with an attorney, and I think they need to be comfortable. They need to feel that they can pick up the phone and talk to the attorney. So I think that's important. Knowledge of the subject matter, obviously. They want to have an attorney who's handled custody cases, who's handled support cases, who's done divorces, who knows the process, who knows the court system, who knows the judges. If they're in Albany County and they want to go to Albany County Family Court, they want to know that that attorney has been there before. I'm sure that there are certainly some very good attorneys, though, who are just starting out, who they would have a very positive experience with. So I think it's word of mouth, obviously, talking with people, reputation. I think all of those things are important. Different attorneys work for different people depending on their personalities and their needs. Sometimes one colleague just might not hit it off with a particular client, and they come to me and we hit it off, and they say to me, that client was a nightmare, and I would say, well, I got along great with that client, but then my colleague might have an experience the next week with a client who they just felt more comfortable with. I think it's a lot personalities, just like everything else.
Thank you so much,
Joanne
Joanne White of Latham. You've
been
very informative, and I thank you for taking the time to be with us today.
You're very welcome.
We will have your name and phone number listed at the end of this program, so if anyone needs or wants to contact you, they'll be able to. Thank you again.
Thank you very much. Okay.
Thank you for being with us today, Parenting in the 21st Century.
Welcome to Channel 17, the Town of Colonie Government Channel.